now in session. Please be seated.
Welcome, everyone. Introductions, please.
Good afternoon. May it please the Court, Carmela Keener of Kuchin Taylor on behalf of Appellee's Arch Insurance Company and Travelers Casualty and Surety Company. I'd like to introduce the Court, my co-counsel, Jeffrey Ward of Dyke & Magossett, and Michael Goodstein of Bailey Cavallari. Mr. Ward will make the argument today on behalf of the appellees.
Thank you very much and welcome.
Thank you.
May it please the Court, Curtis Crowther from Robinson & Cole. I represent Access Insurance Company, the appellee. With me today is Erica Kirstein from Robinson & Cole, New York. Pleased to be here, Your Honors.
Thank you. Welcome.
Good afternoon, Your Honors. David Seal with Potter Anderson and Caroon on behalf of appellants and plaintiffs below, Infinity Q Capital Management, LLC, Leonard Potter, and Scott Lindell. With me today at council table are Ken Frenchman and Andrew Bourne of Cohen Ziffer. Mr. Frenchman will be presenting on behalf of appellants today.
Thank you. Welcome, and you may proceed. Well then, wait a minute.
It's a full house today, Your Honors.
Okay.
Amy Dudash from Morgan Lewis, here on behalf of Appellants Trust for Advised Portfolios, on behalf of itself and the Infinity Q Diversified Alpha Fund, a series of the trust, Christopher Kazmierek, Russell B. Simon, and Stephen Jensen.
Thank you. Mr. Newell.
Good afternoon, Chief Justice Seitz, Justice Valahor, Justice Traynor. Ryan Newell from Young, Conway, Stargate, and Taylor on behalf of Appellant James Velasaris. And with me, Your Honors, Hunter Winstead from Gilbert LLP and my colleague Michael Alcaides from Young, Conway. Thank you, Your Honors.
Thank you. All right, false start. Now you can go.
Thank you, Your Honor. May it please the Court. My name is Ken Frenchman from Cohen Ziffer, Frenchman, and McKenna. I'm here for appellants Infinity Q, individual insureds Leonard Potter and Scott Lindell. This is an insurance coverage case. Appellants are seeking coverage for securities class actions, for an SEC investigation, for an investigation by the U.S. Attorney's Office in the Southern District of New York, and some other underlying actions. But there is actually no issue in this case that the policies insuring agreements provide coverage for these underlying actions. The issue in this case is whether the warranty letters that were issued by Infinity Q at the time of binding were breached, thus eliminating coverage. The court below, the Superior Court, ruled for the insurers and determined after very limited discovery, where there was no testimony, that the warranty letters were breached and that eliminated coverage for all insurers. Now, we believe that the trial court erred in three primary ways. First, the Superior Court decided disputed issues of fact on a limited, only documentary testimony. As I said, documentary record, no testimony on summary judgment. And in doing so, construed this evidence, the disputed issues of fact, from, frankly, very many vague, unexplained communications that were pieced together, provided inferences from those documents without assessing the credibility and hearing from the witnesses themselves. We believe that's contrary to the standards on summary judgment and an error as a matter of law. The second issue we take issue with is the Superior Court's finding that essentially, when we made our first summary judgment motion and the court determined that more discovery was warranted, we believe that the error was not in granting that request for discovery. That's something that the court certainly has the power, authority, and discretion to do. But what that necessarily meant is at that time, the insurers could not satisfy their burden with regard to eliminating coverage based on the exclusion in the warranty letter, such that there was a potential for coverage, such that there was an advancement obligation. And we believe that that turns Delaware law on its head. And finally, and perhaps this is most important, the Superior Court erred by failing to enforce the severability provision in the policies, in these non-rescindable policies, such that innocent insureds, and a primary example of that is my client, Mr. Potter, who had no knowledge of any facts that may give rise to any claim, and he lost his coverage because that severability provision was not enforced. Now, as I go through these issues, I actually want to start with the timeline of events. So this started really, as is relevant here, May 13th, 2020. That was when Infinity Q received an inquiry letter from the SEC. Now, this inquiry letter asked for all sorts of information. It asked questions. Some of these questions were related to how they value their portfolio of assets. But it was a notice of questions. There were no allegations of wrongful acts. In fact, it says on the notice itself that this does not mean that you or anyone associated with Infinity Q has violated the law. It says we have no negative opinion of anyone, but you have to answer these questions and you have to provide this information. And that's exactly what Infinity Q did. They responded.
I'm sorry, finish it, go ahead.
No, go ahead.
I want to press on that. I have one of the letters in front of me, and it says, isn't it fair to characterize this letter as saying that an enforcement action may result from this inquiry? I mean, it says, please note that in any matter which enforcement action is ultimately deemed to be warranted, certain things will occur. Isn't the fairest reading of that one of the possible outcomes of this inquiry would be an enforcement action?
Well, certainly you have the SEC asking questions, but you know, I mean, I think that if it's construed, if the warranty letter, which is obviously what you're getting to, is construed that broadly, that, well, they may give rise to a claim. I mean, they also invest a lot of other people's money. That may give rise to a claim. I mean, there's lots of things that could give rise to a claim. The question is, you know, how far down the spectrum is this? You have the SEC simply asking for information. And, you know, at the time they were starting to make a push on how are assets and with investment advisors being valued. And, you know, in this particular case, Mr. Valenceris, who was the chief investment officer, he had discretion to value these swaps, which were the financial product at issue, and they had a right to ask the questions to see how that is being done. But that in and of itself, just because it could potentially lead to something in the future, I don't think gives rise to our clients' you know, obligation in the warranty. Well, this may give rise to a claim, because like I say, a lot of things they do in theory could give rise to a claim. You take other people's money, you invest it, the stock market goes down. Well, that may give rise to a claim.
Not really the same thing as an inquiry from a governmental entity with enforcement powers.
But it's not a wrongful act, right? They're not saying you did anything wrong. They're collecting documents
To determine whether you've done anything wrong.
To determine whether you've done anything wrong, but they can always do that. They're the regulator, that's their job. Anytime they do any sort of examination and look at things, they could find something wrong and they could, in theory, enforce this. But it's not a claim under the policy. I mean, that's undisputed. It doesn't trigger the claim language. There's no wrongful act. And, you know, frankly, you're in a situation where, you know, okay, anything's possible. You can read it in that way. But to suggest that this means there's a target on your back, I think is, not giving the credit that is due from the words in the inquiry itself, which, says the things that I mentioned.
You don't just get SEC letters for nothing.
Look, I look at it.
I mean, it's just trying to be practical here a little bit. And we understand why all of those caveats are in the SEC letter, because they don't want to injure someone's reputation if there ultimately is not an enforcement action. But you get a letter because they are investigating something. And then you look at the language of what needed to be disclosed, and it might any leading to a claim. I mean, it just seems to be define practical interpretation of what was going on here, your position.
But if you had done nothing wrong and you think you acted in the best interest of your company and did everything right, and you get an inquiry, I mean, if I get a letter from the IRS saying I'm being audited, I paid my taxes, I paid every cent, I'm not happy about it, it's a pain, right? I may send an email similar to the one that Mr. Lindell sent, WTF, what the fudge? But is that because, I think there's inevitably going to be a claim? Or is that because, well, now I got to deal with this? We got to respond to these questions. That's no fun. We have to talk to the trust and get documents produced. We have to incur the cost. We got to figure out what this means from the lawyer. But that's a far cry from the evidence that was relied upon by the trial court to say, see, they knew there was a claim coming in. And frankly, the inquiries were known about during the first summary judgment motion, right? And Judge Davis did not, grant or deny our motion, did not say there's no potential for coverage. What the judge said is, well, let's stay this motion and give them some discovery. And that's one of the fundamental flaws, because you had a judge who actually implicitly decided that there's a potential for coverage. There's a chance. Because if there wasn't a chance, he would have denied our motion and dismissed the case because there's no potential for coverage. Instead, well, the inquiry letters may not be enough. Let's see what else you got. And at that moment, advancement should have been granted.
So let's talk a little about advancement. In the insurance context, it can't be that the insurance company, sorry for the double negatives, that they can't say a claim is not covered, therefore we're not advancing. I mean, that's a possible scenario, right?
The claim is not covered, we're not advancing.
Right,
yes.
right, okay.
And that's what the insurer said here.
Right. And so that's not wrong if there ultimately is not coverage, right?
Well, if there's ultimately not coverage, that may not be wrong, but you should be getting advancement until such time as they're able to satisfy their burden that there is no coverage, right?
So this is where I'm trying to press you a little bit.
Yeah.
And that is, where's the line here? The insurance company has to have room to say, this claim isn't covered, we're not going to advance. And your argument, which is, if it hasn't been adjudicated yet that there's no coverage, therefore you have to advance.
Well, I haven't argued that at the time of the summary judgment motion, the first one, that immediately, even if the court ruled against us, we were entitled to advancement up till that point in time. I suppose I could argue that, but I haven't argued that, and I think that's the scenario you're getting at. They said there's no coverage. We said there is coverage. We brought a suit. We made our motion for summary judgment. The court was in a position to decide that motion. And the court could have said, they were right. There's no coverage. And therefore, there's no advancement obligation, and you guys are out. Court could have ruled that. Court did not rule that. The court considered the motion, presumably thought there were good arguments each way, decided that this was too limited a record to make that ruling on, ordered limited discovery, stayed the motion in the meantime, and that was reheard, I don't know, in August of the next year. I think this was November. So during that time of discovery, all the way until then, until an insurance company satisfies its burden of proof that the exclusion eliminates any potential for coverage, there's an advancement obligation. And what the court's ruling did by prolonging that is that's frankly an invitation to every insurance carrier whenever there's a prior loss exclusion at issue, a prior proceeding exclusion at issue, a relatedness issue out there. Well, Judge, we need discovery on this. We're not advancing yet. We need discovery. We should be able to fish for these documents. They won't put it that way. And they will try to satisfy their burden to eliminate any possibility of coverage. But that turns Delaware law on its head. We see that in the insurance context. We see it in the advancement context as well, actually. In terms of corporate indemnities, right? The theory behind Delaware law, as you all know, is, things like that, advancement, we figure that out on the back end once we know the answer. But no questions asked. If there's that potential, if you owe that now, you advance the costs. And in fact, in this policy, there is a recoupment provision. There is a provision that says you can require the insured to post an undertaking, and that undertaking could be used to recoup the money if it turns out that they weren't entitled to the money in the first place. But what the court shouldn't do is, we already waited by the time we gave notice, got a response, filed the lawsuit, filed the motion, got to oral argument. That's November. We gave notice of the claim in February of that year. And now ordering discovery, having a second argument of summary judgment, which was heard in August. Now we're a year and a half in, and they haven't advanced a nickel. And they hadn't, prior to that time, been able to satisfy their obligation that they have no potential for coverage.
Let me ask you about that. The formal SEC investigation began in late 2020, correct?
Yes, fall of 2020.
Was that disclosed to the insurance company?
Well, it actually wasn't disclosed to Infinity Q at first. They don't get notice of the order. It was disclosed within 2 months, I believe.
All right. So that had already happened by the time the insureds filed suit, correct?
Infinity Q filed suit. But yes, that had happened. The inquiries happened, prior to
inquiries
the
were early 2020.
Right. And then about a month after binding the policy is when the informal investigation order was issued by the SEC. In terms of when, my client didn't find out about that until November-ish.
What I'm trying to get at, by the time that the insureds filed suit, had the SEC's activity escalated to the point where if the insurers had full knowledge of what was going on, they would have been able to show that coverage was excluded? Or was this a matter where the insurers were kept in the dark about the status, and that's why they needed discovery?
That's an interesting question. I think actually the inquiry had happened, the investigation had happened, but that stuff does not interfere with coverage under the policy. It's a question of whether the warranty was breached, and that question is at the time. That question is at August 20th, 2020. So what the insurance company may have learned about these claims and where this claim went in the future actually isn't really relevant to the prior knowledge exclusion that they're relying on that's in the warranty letters themselves. I see don't have too much time, so I'd like to reserve the rest for rebuttal.
Thank you very much.
Thank you.
May it please the court. My name is Jeffrey Ward. I represent Travelers Casualty and Surety Company of America, and I will be presenting argument today on behalf of all three excess insurers. The Superior Court correctly granted summary judgment for the excess insurers. The undisputed facts demonstrate conclusively that when Infinity Q submitted the warranty letter to procure the excess policies, insureds had knowledge of facts or circumstances that may give rise to a claim. And those facts and circumstances, in fact, did give rise to a claim just several weeks after the policy's inception. And it's important to keep in mind what the specific wording of the warranty letter and its prior knowledge exclusion is. It said that no insured had knowledge of any facts and circumstances that may give rise to a claim. Not would give rise to a claim, but may give rise to a claim. And it said that if any insured had such knowledge, then any claim arising from those facts and circumstances would not be covered. Here, the undisputed facts indicate that there was such prior knowledge. The SEC inquiry began in May of 2020, and Mr. Velasaris and Mr. Lindell both received copies of the SEC inquiry letters. They passed those copies on to the board of the trust, and so multiple insureds were aware that the Division of Enforcement had commenced an inquiry to determine whether Infinity Q's asset valuation policies and practices violated the federal securities laws. These were facts and circumstances giving those insureds knowledge that a claim might be made. And they didn't have to know a claim would be made. It wasn't required that a claim was inevitable, to borrow a word I think my opponent used during his argument. Simply required that they had knowledge of facts and circumstances that may give rise to a claim, and they clearly did. We know this not only from the inquiry letters themselves, which did indicate in their own terms that an enforcement action might be deemed warranted, but also we know this from emails and instant messages that ultimately were produced during discovery that showed that Mr. Velasaris and Mr. Lindell were communicating with each other about this SEC inquiry. And they knew it was out of the ordinary. It was not a routine examination. It was an inquiry and investigation commenced by the Division of Enforcement. And they exchanged press releases showing that the SEC had an enhanced program to look into whether asset valuation like this was being handled appropriately. And they exchanged a press release indicating that the Division of Enforcement had brought an enforcement action against a portfolio manager for mispricing very similar investments. So the undisputed facts showed that insureds had knowledge of the potential claim, and therefore the various notice matters that arose out of the SEC's inquiry are not covered because of the warranty letter and its prior knowledge exclusion.
So could you help us with why any discovery was needed in the case, and help us, because the trial judge ordered limited discovery, why that didn't trigger the advancement obligation?
Certainly, Your Honor. First of all, no discovery was needed because at the time of the original hearing on the motion for partial summary judgment, Infinity Q had finally and belatedly turned over the SEC inquiry letters. Some discovery was warranted because the record presented to Judge Davis clearly showed that the insureds had been stonewalling the insurer's reasonable investigation throughout 2021. And the facts that triggered the warranty exclusion's prior knowledge exclusion, they existed. They existed before the policy even incepted. And they were in our opponent's possession and could have been turned over to the insurers at any time when the insurers commenced their coverage investigation after the underlying matters were tendered. But they didn't turn them over. Instead, they delayed, they responded to our inquiries asking for communications with the SEC by refusing to give them, and then they filed suit, and then they rushed the original motion for partial summary judgment to try to get a premature ruling and an advancement obligation that never existed, because the prior knowledge exclusion at all times, based on the true facts, was triggered. There was never a moment in time when the policy provided coverage for these particular matters because they arose out of facts or circumstances known to insureds prior to the policy's inception. So let me move on to discuss the issue of severability, because this is a key issue. And it's one that the Superior Court absolutely got right. The Superior Court correctly ruled that the language of the warranty letter and its prior knowledge exclusion is unambiguously non-severable. The exclusion applies if any insured had any knowledge of facts or circumstances that may give rise to a claim. And there is no room in the unambiguous language of this exclusion to rule that so-called innocent insureds have coverage, notwithstanding the fact that other insureds had knowledge of the potential claim. The severability provision in the primary policy that my opponent relies upon does not create coverage for two reasons. One, that severability provision, according to its own language, was limited in effect only to a specific exclusion in the primary policy, which is not the exclusion the insurers are relying upon. And second, even if the primary policy's severability provision somehow could apply to this separate prior knowledge exclusion that is incorporated only into the excess policies, the excess policy's unambiguously non-severable exclusion would control. The primary policy terms, to the extent they're inconsistent with the excess policy's terms, cannot override terms that appear only in the excess policies. That's fundamental. These are follow-form excess insurance policies, but they only follow form to the extent that the primary policy language is not inconsistent with specific language controlling the excess policies. So the severability provision doesn't apply, and the Superior Court correctly applied the unambiguously non-severable prior knowledge exclusion. Another issue I'd like to hit upon is that even if let me back up, excuse me. So one of the issues my opponent touched upon was that Judge Davis ruled on summary judgment without hearing any testimony. That was not in any way an error. The trial court is required to decide cross motions for summary judgment that are presented based on undisputed facts. And both parties submitted a record of undisputed facts to the trial court, and that record did not include any testimonial affidavits, and it did not include any deposition testimony. But the reason for that is that the insureds resisted depositions and asked the trial court to rule without them. And when Judge Davis continued the original motion for partial summary judgment, he did so at the insured's request with the most limited possible time period and the most limited possible scope of discovery. So Judge Davis continued the hearing for just 60 days, during which the parties exchanged written discovery that was limited only to communications between Infinity Q and the SEC about the inquiry, and internal communications at Infinity Q and the trust about the inquiry. But Judge Davis put very careful limitations on the scope of that discovery so that none of it would address the merits of the securities fraud that was at issue. He did this to protect the insureds from any prejudice that might result from that. And it was an appropriately limited scope of discovery, something that was absolutely within the trial court's discretion. And my opponent on this issue is confusing two separate issues. For the trial court, there was the issue of determining whether the prior knowledge exclusion applied. And that is an issue of law that this court should review de novo. But a separate issue for the Superior Court is when it should make that determination. And when it should make that determination is an issue that is subject to the trial court's discretion. And here there was no abuse of discretion there because the Judge Davis had a record showing that the insurers had reasonably attempted to investigate the facts or circumstances, would have learned the facts or circumstances that would have eliminated any requirement to advance before the motion came before him. And in fact, when the motion came before him, we were able to present the inquiry letters which triggered the prior knowledge exclusion. At that point, he absolutely could have granted summary judgment for the excess insurers. He chose not to do so at that time, and his ruling continuing the hearing didn't make any pronouncements about how he ultimately was going to rule. So he didn't say, well, gosh, I can't grant summary judgment for the insurers now, but I'll give him a chance to develop some evidence on discovery. He just didn't rule. He decided that because the insurers had not slept on their rights and had been attempting to perform their reasonable investigation, it was appropriate to defer deciding whether the prior knowledge exclusions applied for just 60 days for this brief limited period of discovery. And at that point, based on a somewhat fuller record, he correctly decided that the undisputed facts required a ruling that the exclusions applied.
Why shouldn't this advancement obligation work like it does under Section 145, which require the statute, and I'm not saying it applies here, you're looking to the policy, right?
Yes.
But the statute requires an undertaking, but in your policy you've got this recoupment obligation. So you go down the road, you have some discovery, the court figures out that they're wrong. They have to pay the money back. So why, with that recoupment obligation built in, why doesn't it work the same way 145 does?
If there was some uncertainty about whether the prior knowledge exclusion applied, and the answer about whether it applied was unknowable until some period of time in the future, then an advancement with a right to recoupment would have made sense. But that was not the case here. At the time Judge Davis decided the issue, the facts in the record showed that the exclusion was implicated. There never was a period of time where there was an advancement obligation that would even trigger the requirement to advance the funds and then recoup them. And I think it's also noteworthy that given the way things resulted, there really was never an opportunity to order advancement with a right of recoupment, because when the court decided the issue, the facts clearly indicated that the prior knowledge exclusion was triggered. And even today, we know without any doubt that the prior knowledge exclusion was triggered. Mr. Velasaris has pleaded guilty to federal securities fraud, and in doing so admitted that he knew throughout the time period from 2018 through his removal from Infinity Q that he knew what he was doing was wrong. So even if somehow Judge Davis committed error, and to be clear, he didn't, but even if he did, it's harmless error, because there's no opportunity at this point to advance defense costs when there's any kind of uncertainty about whether the policy applies. There's absolutely no facts in evidence indicating that the insureds lacked the knowledge that triggered the exclusion. And there's plenty of evidence that indicates that it does. And with my few minutes remaining, I'd like to touch on the last issue in the case, which is the prior proceeding exclusions. The Superior Court granted the insurers summary judgment based on the prior knowledge exclusion, so it did not go on to decide whether the separate prior proceeding exclusions also were a ground for summary judgment for the excess insurers. But the court could have granted summary judgment based on the prior proceeding exclusions, and this court also could affirm based on that alternative ground. The prior proceeding exclusions in the different excess policies are worded slightly differently, but in general what they say is that any claim arising out of various types of prior proceedings that were in existence before the policy's commencement are not covered. And the most pertinent language in the exclusions that I'd like to highlight is in the prior proceeding exclusions in the travelers and access exclusions. They apply if there was a prior regulatory proceeding. And here, the SEC inquiry into Infinity Q's asset valuation practices absolutely was a regulatory proceeding, as that term is used in the prior proceeding exclusions. And we know that because the language of the defined term claim includes a formal regulatory proceeding commenced by a formal order of investigation. And the prior proceeding exclusion applies to proceedings that are pre-claim. They don't have to be claims themselves. So if an actual claim is a formal regulatory proceeding, then the simple term regulatory proceeding without the modifier formal has to be a point in time in the SEC investigation process that precedes the formal regulatory investigation. Here, that's the SEC inquiry. So the SEC inquiry triggered the prior proceeding exclusions in the travelers and access policies. And it also triggered the prior proceeding exclusion in the ARCH policy, which applied to any formal or informal investigation. And again, clearly the SEC inquiry is an informal investigation that triggered that exclusion as well. So that's an alternative ground for affirming the summary judgment for the excess insurers. So unless the court has any additional questions for me, I thank your honors for your time and attention today, and I ask that you affirm the Superior Court's judgment.
Thank you very much.
Thank you, Your Honors. I want to hit on a few points. I don't have a lot of time. On the prior proceeding issue, I think we can refer you to pages 23 to 27 of our reply brief. I think it's pretty clear on the record that exclusion isn't implicated. I also want to quickly address the question related to discovery and the kind of initial oral argument. These are highly disputed issues of fact at issue here. That was done on a record with no testimony, no nothing. When we made our motion, it's a duty to advance motion. It's a comparison of the pleadings to the policy, and that's what we're dealing with. We don't need discovery for that. And at the time of our summary judgment motion, we only made a summary judgment motion. There was no cross motion on the warranty letter. So it was them seeking to inject this discovery so that they could attempt to meet their burden to enforce the exclusion. But what I really want to do with this last minute or so is discuss the severability provision, because that is really important. I think it's an important issue of Delaware law, and it protects innocent insureds like Mr. Potter. The severability provision makes clear that knowledge of one insured person can't be disputed to another.
I have a question on that. As I read the provision, it relates to claims arising out of misrepresentations contained in the application.
Correct. And
The ultimate claims for which you sought coverage were not those types of claims, were they? Didn't arise out of the statements made in the application.
We're not bringing claims arising out of the application, but they're saying that we made a misrepresentation in our warranty letter. An application in this policy, unlike any case that they cite, explicitly defines application to include warranty letters. And what you have here is this very important non-rescindable, non-sever or policy with a severability provision in it, so that can't be imputed. And they're saying that the warranty letter overrides that. But it doesn't say anything about severability. I understand their argument, and they make it based upon any claim language. But in Delaware, when you're taking away coverage like that, you need to clearly and unmistakably eliminate any ambiguity, take away that coverage. It's not done here, and this is an important issue. It's important for Delaware board members to serve. If innocent insureds can lose their insurance and lose that protection, that's a problem. And it may be difficult to get board members to serve. I see that I'm out of time, and I apologize for that.
Thank you very much. We appreciate the arguments. We'll take the matter under advisement. Please recess the court.
Please rise.
Thank you.
Hear ye, hear ye, hear ye. All manner of persons having anything before the Supreme Court of the State of Delaware may now depart and give their attendance to the call of the court. Court is now adjourned. God save the state and the honorable court.